My book, Torture Team, tells what I believe to be a truer story behind that memo than that which was spun by the administration. And I want this afternoon briefly to discuss some of the key issues that the memo raises. What were the true circumstances in which it was prepared? What was the real role of the senior lawyers in the administration? And what might be the true nature and extent of their responsibility for the abuse that followed? After the Second World War, the United States led the world in creating a new system of international rules. A United Nations was created, and with it, new norms of international law to protect the fundamental rights of all persons. The Nuremberg Charter contributed to the development of international criminal law, and it was followed shortly by the progressive development of international humanitarian law through the Geneva Conventions in 1949. Common Article 3, as many of you in this room know, of those conventions outlaws the use of techniques of interrogation which might amount to cruelty or abuses against human dignity or torture. In 1984, the United Nations, again led by the United States, adopted the Convention prohibiting torture. It criminalized torture, and it also criminalized, apropos the conversation we've just listened to, complicity and participation in torture. And it put in place an elaborate system of universal criminal jurisdiction designed to snuff out any place of refuge that may be available to the torture and their aides. It was that convention, the 1984 convention, that caused the House of Lords, our Supreme Court in Britain, to rule that Senator Pinochet was not entitled to claim immunity from the jurisdiction of the English courts in relation to alleged acts of torture which had been committed during his time as head of state of Chile. That judgment, that convention, opened the door to the more widespread enforcement of international criminal laws. This is an impressive body of international rules, and one which had coalesced by the mid-1980s into an absolute prohibition on torture in all circumstances. As a matter of law, the situation is unambiguous. Torture is never permitted as a matter of law. Nevertheless, the events of September the 11th, 2001, and I happened to be teaching at NYU on that day, I saw everything happen with my own eyes, have undermined the broad acceptance of that general prohibition. They have opened the door, apparently, to a new path, as reflected in the memo written by Mr. Haynes and signed by Mr. Rumsfeld. On their face, the techniques approved that day are plainly incompatible with Common Article 3 of the Geneva Conventions and with the Torture Convention, and that gives rise to the possibility that war crimes have been committed. The list of requested techniques was divided into three categories. Some of you will know them. Category 1, shouting. Category 2, nudity, forced grooming, use of dogs, and so on. Right up to Category 3, shoving, poking, use of water to create the misperception of suffocation, commonly known today as waterboarding. These techniques had, until that moment, prohibited by the US Army Field Manual FM 3452 as clearly in violation of the Geneva Conventions. And yet the Rumsfeld memo stated, and I quote, speaking in the name of Mr. Haynes, "I've discussed this with the Deputy, Mr. Wolfowitz, Doug Feith, the Undersecretary of Defense for Policy, and with General Myers, Chairman of the Joint Chiefs of Staff. I believe that all join in my recommendation that as a matter of policy, you authorize the Commander of United States Southern Command to employ in his discretion Categories 1 and 2 and the fourth technique listed in Category 3, use of mild, non-injurious physical contact, such as grabbing, poking in the chest with a finger, and light pushing." The remaining three techniques were not rejected, including waterboarding, but they were not authorized for blanket use. They were left open for subsequent use on a case-by-case basis. How on earth did this document emerge? It was first made public on the 22nd of June 2004. The context was the effort of the administration to respond to the growing scandal that engulfed it, following the publication of images of abuse at Abu Ghraib in Iraq, first broadcast by CBS 60 Minutes. The document was presented at a press conference that day by two of the most senior lawyers in the administration, Jim Haynes and Alberto Gonzales. At the time, he was White House counsel to President Bush. He later, of course, became Attorney General. Along with the Rumsfeld memo, a number of other documents were also released that day for the very first time. The documents of significance can be grouped into three distinct categories. The first constituted a set of documents which had been originally attached to the Rumsfeld memo, Aside from the list of techniques, they comprised a legal opinion from Staff Judge Advocate Diane Beaver down at Guantanamo, signing off on the new techniques, a formal request from the commander of Joint Task Force 170 at Guantanamo, Major General Mike Dunleavy, a judge and a two-star reserve intelligence officer who'd been appointed by Mr. Rumsfeld to head the interrogations at Guantanamo, and a document requesting further legal review of these techniques by the then commander of the United States Southern Command, Tom Hill, General James T. Hill. The second category of documents constituted really a single document, the full text of President Bush's decision of February the 7th, 2002, determining that none of the detainees at Guantanamo could claim any rights under any of the Geneva Conventions, including Common Article 3. And then the third category of documents comprised principally the now infamous torture memo, the legal opinion written on the 1st of August 2002, signed by J. Bybee, then head of the Office of Legal Counsel at the Department of Justice, but as we now know, largely written by his deputy, John Yoo, on leave from Berkeley Law School, to which he has now returned and to which I will visit next Tuesday. When Haynes and Gonzalez stood before the press on the 22nd of June 2004 in the old Executive Office building next to the White House, they presented a narrative which described the particular circumstances in which the administration had authorized these new techniques of interrogation. And it had four parts. First, the administration had acted reasonably, they said, with care and with deliberation and always within the law. Second, the administration's narrative concerned the sources of the new techniques of interrogation. Where did the initiative come from, they were asked. The administration pointed directly to the military commander at Guantanamo, Major General Dunleavy, a man Mr. Haynes would later describe to the Senate Judiciary Committee as an aggressive Major General. The implication was that the techniques were not imposed or encouraged by the Pentagon or by the Office of the Secretary of Defense. They came from the bottom up. That was the key message that the administration wanted to spin. The third element of the administration's account concerned the legal justification for the new techniques of interrogation. This was not, said Mr. Gonzalez, the result of legal positions taken by politically appointed lawyers in the upper echelons of the administration, and certainly not by the lawyers in the Department of Justice. The legal advice on which the administration had relied exclusively was that written by Diane Beaver on the 11th of October 2002. It had not relied on the Department of Justice's memo of the 1st of August 2002, written by Messrs. Bybee and Yoo, which was only, said Mr. Gonzalez, something of a stargazing exercise. That document, of course, is infamous because it redefined physical torture to encompass only those acts which gave rise to pain equivalent to that felt with death or serious organ failure. And that said, the administration was not the legal advice on which it had relied. The fourth and final element of the administration's official narrative was to make clear that the provisions relating to Guantanamo Bay had no bearing on the events at Abu Ghraib or elsewhere. Indeed, Mr. Gonzalez went out of his way to set the record straight about this. The abuses at Abu Ghraib, he said, were the result of a few bad eggs down at Abu Ghraib. They were totally unconnected to legal memoranda or decisions taken by the administration. The message is clear. It had nothing to do with us. We were acting as a prudent, responsible government responding to the needs of the military down at Guantanamo.